This video is an introduction to school law. K-12 education in the United States is a highly regulated environment. It is regulated by a variety of state and federal statutes enacted by legislatures. Those statutes are constantly changing and evolving. The Constitution of the United States provides a framework for all legal actions. This means all federal and state laws, all regulations, and all school board policies are subject to the provisions of the U.S. Constitution. The United States Bill of Rights comprises the first 10 amendments to the U.S. Constitution. The Bill of Rights amendments were proposed after the 1787 to 88 debate over the ratification of the Constitution. To address the objections raised by anti-federalists who believed the Constitution created a presidency so powerful that it would become a monarchy. As a result, the Bill of Rights Amendment added to the Constitution specific guarantees of personal freedoms and rights, clear limitations on the government's power in judicial and other proceedings, and explicit declarations that all powers not specifically guaranteed to the U.S. Congress by the Constitution are reserved for the states or the people. There are 27 amendments to the U.S. Constitution. Before the Civil War, the federal government touched American citizens' lives mostly through the postal system. During the Civil War, federal power expanded substantially. James McPherson, an American Civil War historian, stated that 11 of the first 12 amendments constrained federal power. But starting with the 13th Amendment, 6 of the next 7 amendments enlarged federal power. The Civil War centralized federal power. Among the 27 amendments to the U.S. Constitution, some amendments are more applicable to education law than others. The First Amendment guarantees the freedom of religion, speech, press, association, assembly, and petition. The freedom of speech portion has evoked numerous court cases involving students and teachers' rights to freedom of expression. Under the First Amendment, teachers have the same rights as others to express their views outside the classroom. But inside the classroom, teachers are obliged to meet the expectations of the job. It implies reasonable restrictions on the expression of private views. The U.S. Supreme Court have reviewed the teachers' rights to express views outside the classroom. Most states leave issues involving teachers' First Amendment rights and academic freedom to local school or university officials. There are some principles emerged from the Supreme Court decisions on teachers' First Amendment rights. Teachers are free to speak out on public issues. Teachers are entitled to constitutional protection of privately expressed views. Teachers have a right to freedom of association. An unsatisfactory teacher may be discharged so long as the discharge is based on factors other than the teacher's exercise of the First Amendment rights. The Fourth Amendment prohibits unreasonable searches and seizures and the issuance of warrants without a probable cause. This amendment has been the subject of litigation involving searches of students and their lockers. The Fifth Amendment reads in part that no person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without compensation. The self-incrimination clause is relevant to cases where teachers have been questioned by superiors about their alleged activities with subversive organizations. The Fifth Amendment was also brought forth in cases in which states or school boards acquire property for school building purposes. The Ninth Amendment addresses rights retained by the people that are not specifically enumerated in the Constitution. It was brought forth in educational litigation in which teachers have asserted that their right to personal privacy outside the classroom is protected as an unenumerated right. The 14th Amendment is about due process and equal protection regardless of race. It was ratified in 1868 after the Civil War. It declares that all people born or naturalized in the United States enjoy both federal and state citizenship. The 14th Amendment denies states the right to deprive any person of life, liberty, or property without due process of law. It also guaranteed that all citizens equal protection of the laws. The U.S. Constitution does not authorize Congress to enact laws to govern education. The federal government has no authority to interfere with educational system at the state level. So the legal control of public education resides with the states. As a result, federal laws are often spending clause laws. This means the federal laws are enforced by the threat of withholding federal funds unless statutory requirements are met. Theoretically, a state can say no to federal money if they don't want to meet their requirements. But saying no means the state is going to lose federal money for a lot of things in education, such as special education, Title I, and free and reduced lunch reimbursement. What you see on the screen is some Georgia big school districts' revenue in 2018 to 19 school year. Some districts received more federal funding than others, partly because of high percentages of low-income students. On the top of the table, about 16% Bibb County School District's revenue came from federal fund, partly because the median income in the neighborhood was just above $38,000. At the bottom of the table, only 3% of Forsyth County School District's revenue came from federal fund, partly because the median income in the neighborhood was above $96,000. According to the Every Student Succeeds Act of 2015, to receive the federal funding, states are required to develop plans with state academic standards for math, reading, and science. States are also required to administer statewide testing and report desegregated data based on race, gender, socioeconomic status, disability, and English language proficiency. So if states want to receive federal funding, they have to meet the requirements in the Every Student Succeeds Act. The Civil Rights Act is also very influential in American education. The Civil Rights Act is a set of federal statutes enacted after the Civil War in the 1860s and the Civil Rights Movement in the 1960s. In 1866, the Civil Rights Act was introduced by Republicans in Congress. The bill declared that all people, including blacks born in the United States, to be citizens. The bill protects all citizens of every race and color by the full and equal benefit of all laws. This landmark legislation defined citizenship rights in a new manner that made the federal government, not the states, the guarantor of basic rights. It is important to point out that Native Americans were excluded. In the wake of the Civil War, the Civil Rights Act of 1866 was primarily intended to protect the civil rights of persons of American descent born in or brought to the United States. The bill passed both houses by majority. The Senate voted to approve the bill 32 to 12. The House of Representatives approved the legislation by a vote of 111 to 38. But President Andrew Johnson vetoed the bill. He argued the bill trespassed on states' rights. In his veto statement, President Johnson interpreted the bill as a case of reverse discrimination made to operate in favor of Black people who were less informed of the nature and character of our institutions. But the Senate voted 33 to 15 to override Johnson's veto, and the House followed suit by a vote of 122 to 41. The Civil Rights Act of 1875 was enacted by Republicans. President Ulysses Grant signed it into law on March 1, 1875. It outlawed racial segregation in public accommodations, schools, transportation, and juries. But Democratic governors never bothered to enforce it. The law struck fear into those who opposed to racial desegregation. After signing the bill into law, President Grant received a wave of death threats from the Ku Klux Klan. The KKK was funded by Confederate veterans in Tennessee in 1866. Klansmen vowed to support a white man's government and carry weapons at all times. Klansmen put on white hood and robe to represent themselves as the ghosts of the dead Confederate soldiers to terrorize their former slaves. In 1883, the Civil Rights Act of 1875 was struck down as unconstitutional by the Supreme Court. In his majority opinion in the civil rights cases, Associate Justice Joseph Bradley stated that the 13th Amendment merely abolishes slavery, and that the 14th Amendment did not give Congress the power to outlaw private acts of racial discrimination. Associate Justice John Harlan was the only dissenter in the case, writing that the substance and the spirit of the recent amendments of the Constitution have been sacrificed by a subtle and ingenious verbal criticism. The decision ushered in the widespread segregation of blacks in housing, employment, and public life that confined them to second-class citizenship throughout much of the United States until the passage of civil rights legislation in the 1960s. It was the long overdue Civil Rights Act of 1964 that provided the blacks with 1875 legislation protections. Those statutes prohibit discrimination in educational opportunities for students based on race, gender, religion, or color. All Civil Rights Acts are enforced by the Office for Civil Rights. The Office for Civil Rights is also responsible for the enforcement of Title IX. Title IX is a part of the Education Amendments of 1972. This act was designed to protect students from being denied the benefits of any educational program or activity because of gender. The U.S. Constitution does not mention education, and public education systems are established by individual state constitutions. State constitutions require their state legislative bodies to establish systems of public education. The Constitution of the State of Georgia reads, "The provision of an adequate public education for the citizens shall be a primary obligation of the State of Georgia. Public education for the citizens prior to the college or post-secondary level shall be free and shall be provided by taxation. And the General Assembly may by general law provide for the establishment of education policies for such public education." At the school district level, local boards of education are designed to represent the beliefs and values of the community. oversee the expenditure of public funding, and serve in the direct supervisory capacity for the local school districts. Most school board members are elected by registered voters, but some urban school districts have some or all of their school board members appointed by the mayor of the city. Since 1991, the mayor and Boston City Council have had control over the overall appropriation for the Boston Public Schools. The mayor appoints a 7-member school committee, which has control over how funding is allocated, has control over policy, and appoints a superintendent. Since 1995, the mayor of Chicago has had the power of appointing the 7-member Chicago Board of Education, and appointees do not require an approval of Chicago City Council. Since 2002, the mayor of the New York City has had the full control over public schools. In 2002, the Justice Department granted Mayor Michael Bloomberg control of school systems. The school board members were elected by voters, but the mayor appoints the chancellor, who is responsible for the day-to-day operation. School board policy and decisions are open to the public under the state Sunshine or Open Records law. Every state provides a further dissemination of school board actions, notice for the time and place of school board meetings, the legitimate reasons for closed sessions, and the process for closing school board meetings to the public. In the state of Georgia, Georgia's Sunshine Law mandates that all government meetings are open to the public, and that all government records are available to whoever wants to see them. The open meeting law provides exceptions that allow certain closed meetings and some confidential actions, and a government entity may close a meeting only if a specific statutory exception applies. A meeting can be closed to the public only by majority vote taken in a properly noticed and open meeting. The most commonly used exceptions are for personnel matters, but only for discussion and deliberation by the governmental entity, not for votes. In the case District Attorney for the Northern District versus School Committee of Wayland 2009, the district attorney alleged that the school committee violated the open meeting law during 2 executive sessions. The school committee members communicated via email prior to an open meeting about the professional competency of the superintendent and the superintendent's contract. A Massachusetts state court held that email communications between school board members constituted a meeting of the board and therefore violated the state open records law. In this video, I introduced in general education law and regulations at the federal, state, and district level. In the next video, we'll learn tort liability.